And welcome back to this will be our extensive coverage of the election petition, which is presently before the Supreme Court. John Dramani Mahama, I'm sure you do know, who had been a key contestant in the 2020 election, along with Nana Dankwa Akufo-Addo and some 10 others, making a total of 12, had filed a petition at the Supreme Court challenging the results that was published by the Electoral Commissioner. And we'll give you some more detail. My name is Johnny Hughes.
And my name is Berla Mundi. You do understand that the election petition and the hearing, the entire process will take 42 days. The NDC and, of course, former President John Dramani Mahama filed the petition on the 31st of December 2020. Today is the 19th or 18th, actually, of January 2021. And so that means that 18 days out of the 42 days, there's a hearing scheduled for tomorrow after a hearing early on Thursday granting the motion for former President John Dramani Mahama to correct some errors in their petition. And also a motion was granted for the petition to be telecast live. And so we'll be privy to all those details right here on Election Petition 2020 right here on TV3. So look forward to all those details.
Absolutely. And this will be the very second petition that we're witnessing within the history of the Republic of Ghana where, somebody had gone to court to challenge the results of a presidential election. The first one was filed in 2012. It was fought through for about 8 months in 2013. Then the coin had not flipped. It was then candidate Nana Dankwa Akufo-Addo, who now is president, who went to court, was represented ably by counsel Philip Addison. Frank Davis, who is also representing the Akufo-Addo-led faction at this point, was also part of it, and so many other brilliant lawyers. Anthony Dabi was there as well. I remember Chachuchi Kata was also there, and Mr. Thondileta was also there as well. Well, the coin has flipped, and now would have legal counsel Chachuchi Kata and Mr. Thondileta leading the charge for John Dramani Mahama, who is the petitioner. And by the way, by the Supreme Court's own 4th edition on election adjudication in the Republic, we cannot have amicus curiae as we had in 2013, where Mr. Amekuji had joined to provide some, if you like, the NDC as well had joined. Now it's just the person who had stood for the election and had difficulties with the results as been declared who can join. But who's representing the side of the Electoral Commission? That will be Justin Amenuvo and one other. And then on the side of the New Patriotic Party, lawyer Kutu Ampao, Tony Sheshe, as is known, will lead the charge. Frank Davis will be there. Yao Pong will be there as well. And lawyer Mika Promo as well will be there as well. So these are the lawyers who will be seen battling it out. But Bella, what's happening tomorrow?
Well, so like I mentioned earlier, tomorrow would be the first proper hearing, if we could say so, because there was a hearing earlier on Thursday. And so this is where we get to go through the corrected petition, and this is where hearing actually begins. And so we'll be giving you all those details on that. Again, just 42 days from the time of filing the petition up until the verdict is given. And so just to run you through, day 1 was for the filing of petition by petitioner. Day 10 is the deadline for first and second respondents to answer, which they did already. And then there was going to be a 5-day pre-trial hearing. And so day 15 will be the hearing proper where it begins, and the motion will be moved to amend petition. We've seen that already. So hearing is supposed to end on day 21, and then day 42 is when judgment is passed.
Absolutely. Well, so Godfrey Tanam will join us. He's our court correspondent. He's been keeping a close eye on what's happening at the Supreme Court. But Bella, there's something that has come to our attention right now.
Indeed. So Ghanaians await the commencement of the election petition filed by the NDC 2020 presidential candidate John Dramani Mahama. My colleague Godfrey Tanam has been finding out preparations by the petitioner and second respondent's legal team.
The processes involved in legal battles in the court of competent jurisdiction at every point requires some explanation for laypersons, from the filing through case management conference, hearing and finally judgment are the processes many anticipate to get first-hand information and understanding. What even heightens the interest is high-profile ones. This is the second time in Ghana's history that the political party has put together its legal team and evidences over a presidential election.
Expectations are high as the country awaits the commencement and judgment of the election petition filed by the 2020 presidential candidate of the NDC, John Dramani Mahama. The NDC has a strong view they have a case, and the Apex Court will rule in their favor. On the other side, the Electoral Commission and the President, Nana Akufo-Addo, believe that the right things were done in declaring the results of the 2020 presidential elections. No matter what it is, the Supreme Court has the mandate to determine the outcome of the results. When the case starts proper, both local and internationally, interest will be raised, and many, whether patiently or impatiently, will be eager to know the outcome of the election petition.
NDC's 2020 presidential candidate filed this petition on December 31, challenging the legitimacy of the presidential election declared by the chairperson of the Electoral Commission, Jean Mensah. This was followed by a motion which was amended after some mistakes were detected. The Electoral Commission, the first respondent, and the second respondent, Nana Akufo-Addo, have separately filed their responses. In their respective answers, the two described the petition as one that lacks merit, incompetent, and does not raise any reasonable course of action. But how prepared are the petitioner and the second respondent?
We will leave it to the courts. In the new rules, the rules indicate that the courts may allow live telecast. And I'm on record to have said that we will request for it to ensure that Ghanaians can follow the proceedings in their homes. Because this is a matter which is of interest to all Ghanaians.
The lawyers of His Excellency, the President, Nana Dankwa Akufo-Addo, expect that the petition be dismissed without going into it at all, because they don't believe there's any merit in the petition whatsoever.
The parties involved are anticipating the Supreme Court to heed to their request, but what are their chances?
I know that clearly we will vindicate ourselves in court, but those who are to pronounce on the verdict are the Supreme Court judges. We also have the Court of Public Opinion, who would also be looking into the matters via their television sets, and they also form their opinion.
The total valid votes was 13.1, which is what she used to determine the percentages. But this is what the NDC petition seems to be about. I don't think it's an argument that will find favor with the court.
For the EC, it was misconceived and untenable for the NDC presidential candidate John Mahama in the petition to rely on the error made by the chairperson of the EC on December 9, 2020, when she inadvertently mentioned the total number of votes cast as the total valid votes. Godfrey Tanam, TV3 News, Accra.
And in the coming days, Godfrey Tanam and the rest of the team will be stationed at the Supreme Court to bring you very fine details. Also, you get all the exclusives and the quick updates on Election Petition 2020. Just to run by you, the composition of the bench in this particular matter, we would have the Chief Justice, His Lordship Justice Kwesi Anin-Yeboah, who will be the president of the bench. Also have Justice Yao Apa will be there. Justice Bafusao, Justice Nene Amegache, Justice Professor Ashi Kote, and Justice Mariama Owusu, and also Justice Gertrude Tokono. These will be the 7 who will be the arbiters in this particular matter, the petition filed by John Dramani Mahama against the Electoral Commission and Nana Dankwa Akufo-Addo. That's Justice Kwesi Anin-Yeboah. He is our Chief Justice. He will be the president of the bench. Also Justice Yaopo, Justice Bafusao, Justice Nene Amegache, Justice Professor Ashikote, Justice Mariam Owusu, and Justice Gertrude Tokono. They will be the 7. And you saw them already last week until they adjourned till tomorrow. And tomorrow it will be a full court session. We've been joined in studio by lawyer Dennis Ejay Jumo, and he will guide us through what you need to know. And I'm sure that you've been following proceedings as well. And we'll ask him quickly. Counsel, thank you very much for coming. Happy New Year to you.
Same to you.
How did we get here?
I think how we got here was very simple. We had an election. By practice, anytime there's an election, there is a possibility that people may disagree with what has happened. From the time that we even started the registration process, and the registration process has been deemed as, the golden key that opens the golden door to exercise your right to be elected.
Right.
Even in student politics, there are times where avenues for challenge is allowed, and so we got here as a result of we going for a public election, presidential election, on the 7th, 9th declaration made. People are dissatisfied with the coalition. The rules and the Constitution of Ghana gives any citizen of Ghana, which now has been interpreted to mean the person who's been affected by election, to challenge the process, and that's how come we got here. So it's basically one of the losers in the person of the former president exercising his constitutional right that is guaranteed under law, and the grievance procedures that has been guaranteed in terms of the law, and that's why we are here.
I see. The concern is what difference we're going to see in this particular petition compared to what we saw in 2012. Already the Supreme Court has, by its manual, had given us a 42-day period within which you will file, respond, and do pre-trial and hear cross-examinations, blah, 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 and then finally give their ruling. Within the 42-day period, that's what they said. Okay. What else are we going to see different?
Okay, first of all, the correction that has to be made is that the 42 days is not by the manual.
Okay.
The 42 days is guaranteed under law.
Right.
When we pass the rules that governs the Supreme Court procedure. So in terms of Supreme Court, there are most of exercising the jurisdiction of the court. Some of them happens to be an appellate process where you appeal from the Court of Appeal to the Supreme Court. Some of them is constitutional. So when it comes to constitutional of right, you go directly to the Supreme Court. Some of them is a reference jurisdiction where there's an issue that appears before a court below and there's a constitutional matter in is referred to. So our Supreme Court, it's not like other courts like in South Africa where they have a constitutional court which deals with only constitutional matters. Our Supreme Court exercises several jurisdictions. So in terms of election processes, and bear in mind in terms of public election, it's presidential, there's parliamentary, there's district assembly elections. So public election, when it comes to presidential, it is where your right, the forum which you litigate is that of the Supreme Court. And when the Supreme Court the 1992 Constitution came into effect on 7th January 1993, and later on we passed the Supreme Court rules of CI 16, and we had never experienced, there have been several amendments to the rules. So the last amendment that was made to the rules was the one that now, based on the history that we had with 2012, the Supreme Court now gave its timelines of how the whole thing is given. And it's foreseen that it will be dealt with in 42 days.
Okay. I see. So then it will be in tandem with what the learned editor of the Supreme Court, Ghana Law Reports, Dr. S.Y. Bimpombuta, who had also mentioned that in the matter of trying to join, where we saw Amicus Amekuja is now coming to be called, and the NDC and others joining, we should restrict it to the people who are directly affected by correct?
Yes, that's correct. Because what happens with the most respected Bimpombuta, who contributed immensely to the law, which some of us revere in terms of the work that he did. Anytime he comes out with his law report, so he came out with the Supreme, he was first the Ghana Law Report, the chief editor of Ghana Law Report, then decided to set up his own practice and came up with the Supreme Court of Ghana Law Report.
I see.
What he does after reviewing every case he has an editorial, and as part of the editorial that he did, so if you ask legal practitioners, he did an entire law report for the election petition, which is captured in the 2013 special edition of the Supreme Court of Ghana Law Report. Therein, he then made some of these things. And it was 2012 happens to be a novelty because the rules had not yet been tested. And for that matter, things were done in a certain way which delayed the process. And we understood the impact on the economy, even in terms of litigation. So the recommendation that was made was one of those recommendations, which is now captured in the rule. It's now captured in the law. So there is now clarity. There are certain people who school of thought who holds that the right to join actions should be determined based on the course of action. But now, quite clearly, the rules have made it quite clear that there cannot be any joinder, there cannot be any amendment to the grounds, there cannot be any amendment to the petition, just to ensure that there will be swift and effective justice.
Okay, but when you say there cannot be amendment, then you're talking about the crux of the matter that you're bringing before the court, and not typos, for example, because we saw last Thursday that the Supreme Court granted the petitioner, Chachi Chikata and Tony Lita, who had represented John Mahama, who was in court as well, so the laxity to go and correct something?
I won't say the laxity, because if you clearly see the position of the court is to look at substance, right, and quickly go about it. That notwithstanding, because it related to typos, and the court were quite, if you look at the position of the judges, although there were affidavit in opposition to the court's position, was that let's look at the nature of the errors that was made, and we think that it does not, in substance, it does not affect anything. And for that matter, we can correct it and move ahead and quickly resolve the matters. So the court posture, and bear in mind that the rules of court is a handmaid, not a mistress. So the court is supposed to serve as a guide. It does not, although there were amendments to those portions of the rules, the power of the court to waive the rules, sometimes to do substantial justice, is still guaranteed under the rules. So I think that in terms of the portion of the court, was how best we can, these are typos that can easily be understood. And from patent reading of it, these are things that can easily be corrected. So the portion of the court was that let it go ahead. But people should understand that when it comes to some of these things, it's the discretion of the court. Okay. The court evaluated this circumstance and said that it's okay to amend.
As to whether to shut the door or not.
But there can be situations where the court, in exercise discretion, might think that in this circumstance we should not allow you to amend. So just as situations where the court agrees with somebody, the court sometimes can agree with your position. And it's not a matter of whether you have lost or you have won, but it's about dispensing justice. And whenever you decide to dispense justice, certain times people will not be happy about it.
Tomorrow, I understand, will be pre-trial, correct?
Yes.
Now, what's pre-trial?
Okay, so pre-trial, basically the step that the court have instituted for us to look at the entirety of things that will happen in trial. So in terms, and as I said, the concept of pre-trial in terms of election litigation is quite, where the rules are now made, it's quite novel when it comes to election, but it's not novel when it comes to what happens in the lower court, like the high court. What often happens is that the court will evaluate on it. For instance, if you could clearly see NDC indicated in their petition that they intend to call 6 witnesses. The court will evaluate it at the pre-trial and say that, why do you need to call 6 witnesses? 5 or so. 5 or 4 or whatever. Because if you look at the 2012, nobody called 5 witnesses.
That's right.
So why do you, and if you look at the nature of the facts that you have deposed to in your petition, which narrates everything that everybody you're supposed to know, why do you need to call 5 witnesses?
You have to justify why you need
the court at the end of the might say that no, looking at A, B, and C, or the lawyers sometimes concede, and my lord, we said it because sometimes you also want to be careful. I prefer to plead that I'll call 5 than to say 2, and later on I might realize in terms of strategy I need 3.
Right.
But tomorrow we'll get to know how we'll go about how many witnesses will be called. We also get to know last time where the court might give a direction whether we should go by affidavit evidence.
Right.
And so it means that whoever you call as your witness, let a person go back, swear to an affidavit, depose to the grounds for which and bring the documents to support the submission that you have made. And then the court would then, based on that, call another party to cross-examine if they think there is any dispute.
Okay.
Otherwise, proceed. So basically, the pre-trial is to set the tone of what to expect in the trial.
Okay.
How many witnesses will be called, if there are any objections or anything of that sort, how many people, how we're going to raise it, and how we're going to deal with it. So it's basically, at that time, the court and the lawyers, looking at the petition and the answer that's been given, will give a roadmap on how the trial will proceed.
How the trial will go. So you agree on everything, and then the match starts.
Yes, but bear in mind that ultimately what the court say will be final.
Okay.
So there will be an instance where lawyers might think that I will need 10 witnesses.
Okay.
The court will take a position that you don't need 10 witnesses.
Okay.
And for that matter, you are seeking to delay the trial.
Okay.
We think that you can use 5 witnesses to deal with this particular matter. Whatever the court will say will be final. Because the court also understands that if we have given a roadmap of speedy and effective justice of 42 days, practitioners sometimes, we do have tricks in our bags. So if the court does not guide us, we might take the court hostage. So we should bear in mind that the court has the ultimate power to determine how things will go. But by practice, it's always done with consensus from the bar.
Okay. And this pre-trial is supposed to take how many days? 5 days?
No, pre-trial can take 1 day.
1 day.
It will take 1 day because just directives and stuff like that.
If they don't agree tomorrow, for example, and maybe
Who don't agree?
If somebody flies in something that, you know, both parties tend to have a pull and push about, is that possible, by the way?
It's possible, but the court will decide.
Okay.
So if you realize from 2012 election, every single motion that was filed was opposed and a full ruling that was given. There was a joint application, was opposed, a full ruling given. There was further and better particulars, opposed, full ruling given. And that's what the court have decided to cut this thing down.
Okay.
And for that matter, there will be, the last time that we went to court, the amendment application that was filed, it was opposed by the EC, opposed by MPP.
That's right.
The court took a decision, and we all respected it, and we have moved ahead with the orders that were court.
So it rests with the court to make that decision.
Yes.
Then we go to 15 days hearing.
Yes.
This will be after the pre-trial
Yes.
period. 15 days, is it not too tight, one would ask?
As I said, I will wait and see what will happen at pre-trial. If it happens to be a situation where the court parties agree that we will not call more than one witness and we go by affidavit evidence. Now, bear in mind that the nature of the allegations that have been raised in the petition is not too much too much complicated as compared to 2012, where, you know, petitioner Nana Dankwa Akufo-Addo raised about 4 grounds and had to justify each of the grounds. You know, the fact that certain polling station agents did not sign it. So there's one ground relating to that. There's an issue about, you know, pink sheet issues here. So there are several grounds that relate to it. Now, if you look at the petition that has been filed by former President Mahama, it goes straight directly to how the EC went about in her declaration, raising issue about vote pardon, raising issue what happened in Techiman. So it's quite, if you ask me, they are not as voluminous grounds as compared to what was raised in 2012. But all in all, the pre-trial will determine it. And on the basis of affidavit evidence, depending on what the court will say, whether they should go by a witness statement or affidavit evidence, that will also determine how long it will take. So I would think that for now, whether it is tight or not, we should wait and see what will happen at pre-trial, the number of people that will come in.
The pre-trial usually would take place in chambers, you know.
Not necessarily. Pre-trial doesn't take place in chambers.
Does it always take place in open court?
It's an open court.
Every time?
Yeah, it's an open court. Apart from divorce matters and matters involving children, where the rule says that it has to be happening in jail. Because the right, in terms of court proceedings, the Constitution required for a public hearing.
Okay.
And in terms of election matters, even it goes up higher because there is a need for us to ensure transparency. And for that matter, the court will not hold pre-trial in camera. People have to see, and the Chief Justice has quite taken an administrative decision that as part of keeping up with the practice and ensuring that every Ghanaian is part of the process, this thing will be held transparently. People will get to know the objections that are being raised, and among other factors.
The last hearing, you know, was quite snappy. Quick and fast, and before anybody could actually adjust to want to watch their TV sets, it was over. Are we to expect a similar thing tomorrow, especially knowing that, you know, they have gone through the filing processes and everything else?
You know, what the court have, it could be possible. It could delay. However, the portion of the court is about speedy and effective justice. We will not allow lawyers to hijack the process. And if you even look at the representation, the court decided that we will not let you even introduce more than 4 practitioners. And that's how come the EC and Nanado's people who represented Nanado had to introduce just 4 lawyers.
Okay.
So you could clearly see from the position of the court that we know the timelines that we have given ourselves under the rules of court. We ensure that we go strictly by it. If the court, before they come to an open court, would have had consensus or they have discussed among matters, and they will listen to what the practitioners will say, and will take a decision on it. So it can be possible that it can be swift, or if people raise objection or anything of that sort, the court can look at same and make a determination.
So now, question is, the issues. I'm sure you've seen the suit and the responses that have come there. Already, I don't want us to get into the court of public opinion, though, but the respondents, I mean, the Nana Dankwa Akufo-Addo faction, Tony Akutu Ampao and Frank Davis and Yaupon, they're asking for the matter to be thrown out even before. I mean, somebody says it's bravado coming at them. For the public, and we saw what happened in 2013, people being committed for contempt and all of that, who have started already running their own summaries and running judgment. What would you say to them?
I would advise that they have to be cautious in terms of statement that they make, especially statement that we make to attack the court. We should allow the process to go ahead, and we'll see what comes out. That's what we have chosen in terms of democracy. People should expect that we will not be excited. Certain group of people will not be excited by the decision that the court will take. Just as happened in 2012, but we still had to live with it, and we have gotten far as a country. And the interesting bit of it is that what the Supreme Court says is final, and you cannot challenge it in any other court. And I think that the justices of the court understand what it is, and then they will proceed with it. Now, the issue about the penal legal objection that has been raised is allowed in terms of the rules.
Okay.
And many cases have been won and lost on the grounds of penal legal objection. And so the court will have to make a determination on saying, the court can take a posture that although they have raised as a penal legal objection, and the idea of penal legal objection is to say to the court that if you look at the nature of process that has been filed, your lordship should just make a determination without listening, going into it. So I'll give you a practical example.
Tell me.
There are situations where you might decide to file an action of trespass against me. However, the person who has actually trespassed onto your land is actually your colleague who was here.
Bella,
who was here. You file an action against me. I go to court and I say to your lordship that, lordship, if you look at you yourself, you agree in your submission that the one who actually trespassed on your land is Bella. And by reason of me being related to Bella, you have decided to bring an action against me. The court can say that, looking at it, you have no cause of action against me, and will strike the matter out without necessarily going into evidence. So those are the penal legal objections. As in how the court will resolve it, there are instances where the court can sometimes say that, looking at the nature of the penal legal objection you have raised, it might dovetail into matters of evidence. So I want to listen to the evidence, and at the end of the day, might decide to give my decision on save. Or if the court also thinks that, looking at the documentation, it's quite patent on the face of it that the penal legal objection should succeed, then so be it. So it all depends on how the court will determine it at the end of it.
Is there a chance for an appeal? If, for example, one of the parties, and in this case it would be the petitioner, is not so excited about it, or if you like, the second or first respondents are not excited about the ruling of the Supreme Court after the 42 days, do they have a chance to appeal? Okay, so first of all, when the Supreme Court makes a decision, nobody has a right of appeal. There's no appeal against Supreme Court decision because the final decision of the court. Okay, but as a general practice. But the Supreme Court may have appellate. No, so I'm just saying that the Supreme Court, in terms of is the apex court. Right. So just before I dovetail back to the election, just to explain that, because I've realized that most journalists are talking about Amewo's decision has been appealed and stuff like that. So when the Supreme Court makes a decision, there's no right of appeal. What the right that you have under law, which is a narrow window, is to go for a review. Okay. And in that review, the court is not going to consider the evidence on those matters. So there have been situations in cases that we have done where we lost by 5-2. And we went for a review and lost by 9-0 because the court felt that we were re-arguing our case. Okay. So review is very difficult to actually get it through. And it's a small window. So you don't appeal against the decision of the Supreme Court. Okay. You seek a review, of it. Okay. And, thanks for clarity. And that review, there have been, the last time review has been, the court hardly, even those who might have voted for you or decided to agree with you, at the time that we were holding a trial, when it comes to review jurisdiction, the court have said that they will not allow, because litigation must come to an end. Right. And for that matter, if we allow people to abuse the review process, then litigation will not come to an end. And for certainty of the law, the court is, hardly would the court rescind on its decision that it has made on exercising its original jurisdiction or supervisory jurisdiction to change same on review. So in this particular case, John Mahama, or if you like, President Akufo-Addo or the Electoral Commission can only go for a review. Yes. They can't go and appeal the matter. What would it mean if they go for a review? It depends on the grounds of review, because if the decision has not been made, it's difficult to go for it. So in Peter Mewu's case, I've heard that they have actually filed a review in the Supreme Court, seeking to point some errors that the court made in its ruling that it delivered. So it all depends on the
the decision that the court will make, but the right of review is guaranteed under law. So anybody can exercise that right. If you're a party and you are dissatisfied.
And that will be for the presidential petition, because then it's at the apex court.
Yes.
By law, it's supposed to be tried there. Let's come down to the issues of parliamentary challenges, where people are challenging parliamentary elections. Can they climb up?
Yes, it can. And there are history of parliamentary climbing up. We were in the case of Sakandi that happened in court. The High Court made a decision. We disagreed, appeal. The Court of Appeal made a decision. But the Supreme Court has held that when it comes to parliamentary election, the final court is not the Supreme Court.
Okay.
The final court is actually the Court of Appeal.
Okay.
So if you appeal from the High Court, and I know about 16 petitions have been filed in various High Courts in the country. Right. After the High Court has made a decision, you have a right of appeal to the Supreme Court, to the Court of Appeal. After that, Court of Appeal make a decision, it's final. There have been instances where people have used constitutional actions to get the matter to the Supreme Court or to the court supervisory jurisdiction. But when it comes to making a determination on the substantive matter, it's the High Court that you go to, and after the High Court, you go to the Court of Appeal. After the Court of Appeal, that's the end of it.
I see. So the window shuts out at that point. The EC intends to rely on a couple of things. So there's a list here. The 1992 Constitution, they talk about legislations, including the Evidence Act 1973, the NRCD 323, Interpretation Act 2009, Act 798, the Supreme Court Rules 1995, CI 16 as amended by CI 72 and CI 99. Also, the Public Elections Regulations 2020, CI 127, High Court Civil Procedure Rules 2004, CI 47, Case Law, Nana Akufo-Addo and others versus the Electoral Commission 2007-2008, the Supreme Court Ghana Law Report 1250. You lawyers like to quote plenty laws. Why?
It's not about we liking. It's actually what the rules have actually stated. The rules have stated that in terms of your answer in your petition, you need to state the facts that you are seeking to rely on. You need to verify the facts. You need to also state the law that you are using to support your position. So once the rules say that we should state the law, both parties are mandated to state the law that support their case, and that's how come you see it. And the laws are reported, and because reporting is basically the source where you are getting that decision from.
Right.
So the law report that you see in there, the various law reports that we have. So it's not because the lawyers like to state it, it's because the rule actually mandates it for it to be stated in the various process that is filed.
What does it mean if I state these, if you like, compendium of laws that I'm going to rely on? Can I go outside of it while we have the trial, while the trial is ongoing?
First of all, the law happens to be in the bosom of the court.
Right.
The court is presumed to know all laws. What you're doing is that, as a lawyer, is that you're an officer of the court, and your duty is to assist the court to dispense justice. So if it so happens that I've stated these are the laws that I'll be relying on, and it so happens that a particular law is relevant, there's nothing that prevents me from pointing same out to the court. Because after all, the laws lies in their bosom. They are presumed to know all the laws. So it will not change because I'm adding a new law to it or not. Yeah.
I see. So thank you very much, Counsel. We're grateful. Any closing thoughts? We got to go. Our time is spent.
My closing thoughts is to, especially to my colleague lawyers, is to allow the process to run.
Okay.
And I would also urge my friends who in the media to not to allow, especially the parties' lawyers, to hijack the process, because understand that when it comes to parties' lawyers, they have an interest to protect.
Right.
It is not just a presidential election petition for most people. It's also a political matter. And for that matter, we should also be careful to allow people to throw dust into our eyes. I think that at the end of the day, allow the court and the process to work, and we'll continue to live with the decision that the court will come. And I think it will be a just decision.
Thank you. Dennis Ajay Jomo is a private legal practitioner. He's joined us to shine some legal light on all of us. Counsel, we're grateful. In the coming days, you see a lot more of him as we get to show you what will happen at the Supreme Court, where John Dramani Mahama has petitioned the Supreme Court regarding the results of the 2020 elections. He is disputing the fact that he lost the elections and Nana Dankwa Akufo-Addo won it. The Electoral Commission has responded, first respondents, and also candidate Nana Dankwa Akufo-Addo has responded. So tomorrow, the court will reconvene and we shall hear from them what it is that we must hear, and you get all the details here. My name is Johnny Hughes. Remember to wash your hands with soap and under running water. Eat healthy, exercise, Take your vitamin C seriously. Also drink a lot of water, rest, maintain social distancing, wear your face mask, and keep hope alive. We'll see you later.